Look, you can claim your Fifth Amendment right, but you can't also make a statement. She waived that right. She's going to come here. Now, she says she'll be glad to come up to Capitol Hill if we'll give her immunity, but we're not interested in giving her immunity. She may have to pay some consequences for what she did or did not do. Right now, we're just trying to get to the truth. Come up to Congress, tell the truth. That's what we're asking her to do.
All right. Well, of course, there's been a vote in the House last week to hold Lois Lerner in contempt of Congress. But where do we go from here? Joining us now is my friend, the great Andy McCarthy, and I'm holding in my hand right here the new book that's out in just a couple of weeks, Faithless Execution, Building the Political Case for Obama's Impeachment, and it details 7 articles of impeachment. Andy, we will not be talking about this book specifically today, but I can't wait to read it and then talk to you about it in a couple of weeks when it comes out.
Thanks, Steve. I appreciate that.
All right. Now, at National Review, where, of course, you are senior fellow at the National Review Institute and contributing editor at National Review, you wrote a piece making the case for Lois Lerner to be granted immunity in order to testify. Why, after she, made an opening statement, claimed the Fifth, many believe waived her right to the Fifth, has been held in contempt. Why do you think they should actually grant her immunity to testify?
Steve, the answer is actually in your question, where you say many believe. The problem is that not everyone will believe. It's actually not a black and white question of constitutional law. On one end of the spectrum, if you make a sort of conclusory profession of innocence, like I am not guilty, most courts would say, I think almost all courts would say, that does not waive your privilege. On the other hand, if you give a detailed exculpatory version of events and then refuse to be cross-examined, you have waived your privilege.
As she did, more or less.
Well, what she did, I think, is really more something in the middle. Okay. She did more than, just a brief conclusory claim, but she also didn't give a blow-by-blow account of what went on. And I think if you ask 100 federal judges, you're going to get very different views on whether that is sufficient to be a waiver or not. But, I want to go back to the piece of sound you played from Representative Chavez, because while I really respect his passion and stick-to-itiveness on this issue, I think what he's saying is a little bit incoherent. If what he's saying is we need to get to the bottom of this, if you're a prosecutor building the case and you have a log jam because you've now hit the person who could help you get up the ladder, but you're not getting any information out of him or her, and they don't have real criminal exposure, or if they do have it, it's very spotty, and you're in a situation where the more important thing than criminal prosecution is finding out politically what happens so we can get accountability and we can change policy if we need to, then the obvious thing is you immunize that person and find out what the person knows and then proceed with the investigation. By doing what they've done, we've now wasted over 6 months, and we're not talking about the scandal. We're talking about this sort of law school exam question of, did she say enough to waive or didn't she? And my point is, I have no illusions that if you immunize Lerner, she's suddenly going to become super cooperative. But I do think at that point, at least if she's obstructive, you're talking about obstruction in terms of the facts of the IRS scandal, which is what we ought to be getting back to, rather than did she waive or didn't she waive. Right.
All right. Now, okay, that's interesting. That's a fair point. But she could still, she doesn't have to. In other words, if they grant her immunity, right, then does she then has to answer questions, or she could still take the Fifth?
She has no Fifth. That's the idea of immunity.
Okay.
It extinguishes your Fifth Amendment privilege.
And then if you don't answer, then it still would be incumbent upon the Justice Department to prosecute, correct?
Well, if it happened in front of Congress, they could detain her. I think that's highly unlikely. In other words, she shows up and refuses to answer, even though they've immunized her.
And they throw her in the clink.
Well, yeah, they could hold her in contempt right there and then, like a court does.
Right.
But I think that's highly
agreed. Yeah.
But the other thing that's to be borne in mind here, Steve, is the statute of limitations on perjury and obstruction of justice is 5 years. The Obama Holder Justice Department is not going to be in power for 5 years. So she will know that she has criminal exposure and that it's very likely at some point in time she'd be prosecuted if she obstructed or committed perjury. So I think that it's more than likely she'll testify. Now, she may try to, like some witnesses do, she may try to put a positive spin on it from her side, but she's got real jeopardy if they immunize her and then she plays games.
All right, well, we're getting nowhere with the status quo. You're absolutely right, because Holder's going to do nothing about the contempt vote. So, she could just ride it out for now, and it'll be interesting to see how that proceeds. You also wrote a piece at National Review talking about how, and this is something that was revealed last week, how Hillary Clinton blocked a terrorist designation for Boko Haram. And I just want to get to this real quick, because there's one other issue I want to bring up too. But what bothers me, certainly that bothers me, but what really bothers me is, and I went over this and I played it all week long, Michelle Obama, and it's not just her, but Michelle Obama giving the weekly address in lieu of the president, talking about how Boko Haram, if you just were listening to her and you knew nothing else, Boko Haram is all about preventing girls from getting an education. They're not Islamic terrorists. They didn't slit the throats of 60 boys in February at a boarding school and set the place on fire. They haven't ravaged churches and killed Christians. They haven't killed thousands of people over the years, and they don't want strict Sharia law. They just are out to prevent girls from getting an education, and that made me sick.
Yeah, it's really preposterous. The now head of Boko Haram, and Tom Jocelyn has, at the Long War Journal, has done some great work on this, and Bill Roggio as well. But in 2010, he warned, in sympathy with al-Qaeda, America, the jihad is not over, the jihad has just begun. They are a group that has been in cahoots with al-Qaeda for a long time. There's some intelligence that suggests that they got seed money at the beginning of their existence from Osama bin Laden. They've certainly had communications and cooperation with the local al-Qaeda affiliates in Africa. This is clearly a terrorist organization. It's not even close. And in fact, the Obama State Department did ultimately list them as a terrorist organization.
And Michelle Obama called them terrorists.
Yes,
but terrorists because they only prevent girls from going to school.
Yeah, well, that's one of their sidelines. I'll admit that they do that, but they do a lot of other stuff.
Yeah, they absolutely do. All right, I'm glad we have time for this. What we learned the other day, the release of 36,000 illegals in this country, criminal illegals, murderers, rapists, you name them, while they were awaiting deportation, released by this administration. Do you believe that in and of itself is an impeachable offense?
I think it's part of a pattern of Obama's faithless execution, his failure to faithfully execute the immigration laws, which I talk about in the book at great length. This is just another notch in that belt. But I do think, Steve, that once the public understands what high crimes and misdemeanors are, they're not like ordinary criminal offenses. They're the political crimes of high public officials in which public trust has been reposed. Once you understand that and understand that his job is to execute the laws faithfully, yeah, sure, it's an impeachable offense. The question becomes, though, is there the political will in the country to remove him from office? I don't see that now, but that's a case that has to be built.
Yeah, well, obviously, and Andy, this is just so egregious, and we've talked about him unilaterally enforcing and changing and making policy without going through Congress, but to release these offenders who committed amongst them 87,000 plus crimes. And again, this isn't reported in the media, in the regular media, so the public doesn't even know about this.
Yeah, you're right that it's not reported in the media, but my sense, dealing with a lot of grassroots, is this is one of those issues that, the Beltway ruling class and the coastal cities in the United States are so not in the same place as the broad run of the American people, and they are keeping their eye on this.
Yeah, well, that's for sure. That's for sure. They know about it through people like you and me and Newsmax and National Review. Faithless execution. Order it now. Pre-order it. The great Andy McCarthy. We'll speak to you soon, my friend. Thank you.
Thank you, Steve.
Take care. Andy McCarthy, ladies and gentlemen. When we come back, it's the Malzberg panel. You're going to love it. I promise. On the Steve Malzberg Show. Don't go away.